much. So I wanted to just chat to you about, for context, the Trump meeting system. What the Chinese vehicle manufacturer.
Right, I do have that.
Okay, showtime. Good afternoon, everyone, and welcome to those of you who are joining us online and to everyone who's here in the room. It's so lovely to be with people in these times. We're all still recovering from lockdown, I think. It's never going to go away. Yeah, welcome. Today's going to be an interesting discussion. We are really starting to look at the power of activism and responsibility around climate change. I think we're all realizing more and more that the responsibilities are starting to become greater and greater. It's no longer just individual people picking up litter. Now we really are following the money and making sure that people they need to bring us climate justice. So today we have a few representatives from the CER, we have people from the CCLI, as well as the IODSA. Just to start off, the CCLI examines the legal basis for directors. Excuse me, I should be telling you guys what our program is first. I'm just jumping straight in. I'm so excited. That's why. Okay. All right. Just to take you through our program, we're going to have the introduction and welcome, and then from 12:40, we're going to have the keynote address by Malo, the Senior Counsel. We will then follow on from 1 o'clock with the presentation of findings and panel discussion by Zara Omar and Leanne Govinsamy. And then we will then later speak to the review of global trends in directors' duties and climate change, as well as reflections on corporate governance and climate change from the King Committee. And I will introduce all our speakers just before they speak so we can all keep up. And then at 1:45 until 2 o'clock, we will have our question and answer session and closing remarks. For those of you joining us online, feel free to pop some questions down as we go. And particularly in the panel discussion, we'll be able to probably respond to those as you
Hi, all. Sorry, in the Johannesburg boardroom, you're on mute.
Thanks all. We're trying to resolve.
I think that we have to do it. Okay, here we go. I think we're back on. Here we go.
All right. Apologies, everyone. So just to catch up, we were just speaking about why we commissioned the opinion, and this is to research and provide credible information about the duties of directors to address climate risk. People who drafted the legal opinion were very lucky to have amazing senior counsel who worked on this, and we're very grateful to them for their efforts. And yeah, I think Leanne's going to cover for us what our objectives are for today's discussion. And before we get started, I'll share the disclaimer. All right.
Yes, well, a huge welcome to you all again. We're really grateful for all the time and the effort that the IODSA, the Commonwealth Climate Law Initiative, has put into this. And we're grateful that you have chosen to spend some time with us here today. Well, the objectives of the opinion really is to look at the climate risks that directors are exposed to and be able to have a deep dive into what those risks constitute. There have been so many changes over the last couple of years, and we wanted to ensure that we have credible information. And therefore, our incredible team of advocates, Sandile Khumalo, Nazreen Raja Badlinda, both senior counsel, Kanya Kanuso, and Nicholas Suko, who have worked on this. So it was really about having a very close look at the issues related to director liability and ensuring that this was as credible as possible. Thanks, no matter.
Right, fantastic. And of course, just a short disclaimer, the legal opinion has been prepared for research and information purposes only and does not reflect the individual views or opinions of the Institute of Directors South Africa and the Centre for Environmental Rights. The views expressed in this opinion should not be construed as providing legal advice for any particular director, company, sector, or circumstance. The opinion presents the status of South African law as of September 2024. Right, and now we're going to jump into our keynote address. If I can just introduce our speaker today. Advocate Sandile Khumalo, who is senior counsel, is a member of the Johannesburg Society of Advocates, member of the Duma Nokwe Group of Advocates, and ABSA certified commercial arbitrator. Sandile holds an LLB, a diploma in corporate law, and a diploma in advanced banking law from Rand Afrikaans University, now the University of Johannesburg, and an LLM in international business law, cum laude, from the Vrije University in Amsterdam, the Netherlands. Sandile teaches pensions law part-time and has since 2006 been a trustee of various retirement funds administered by Alexander Forbes, including the Alexander Forbes Preservation Fund, Alexander Forbes Beneficiary Fund, Alexander Forbes Unclaimed Preservation Fund, the Alexander Forbes Core Plan, and the Alexander Forbes Retirement Fund. Sandile has also been appointed by the Financial Sector Conduct Authority as a trustee, Section 15K tribunal member, and statutory manager to a number of retirement funds. Sandile is also a trustee of the UJ Trust, and since 2018 until now, Sandile has been listed as by Best Lawyers as one of the best lawyers in South Africa in the field of employee benefits law. So we really are very lucky to have him here with us today. And if I could invite senior counsel to please come and join us.
Thank you. I always leave my phone somewhere and switch it off because there's nothing worse than the speaker's phone going off while they're talking. So I'm going to ask all of you, if you don't mind, to just mute yourself so that we do not interrupt the people who have joined online. I have prepared slides. I don't like people writing down and taking notes while I'm talking. I want you to look at me and try to engage if you can. So I have prepared a slide presentation, and everything I'm going to say, it is in the slides. So you don't have to take the trouble of taking down notes. My name is Advocate Sandile Kumalo. I'm a member of the Johannesburg Bar. You've heard the short introduction. The other things that I do in addition to being a member of the bar, I'm also a member of the Financial Services Tribunal and the FIC Appeal Board. And FIC is the Financial Intelligence Center Appeal Board. So we hear appeals that emanate from regulatory institutions and internal banking or financial services issues, such as debarment of key persons who work for banks and insurance companies. Now, the topic, directors' duties and liability for climate-related risk under South African law, is a very interesting topic. And I want to take all of you back to 2016, when the authors of the King Report said, it does not matter whether you still believe that climate change exists or not. What matters now is prepare for it, take appropriate steps to mitigate the risk, because you never know. And they left it there. They deliberately did not go into detail on climate risk. Interestingly, in South Africa, as you know, we have the Companies Act, which regulates in general companies. And then we have special legislation that regulates specific sectors of our economy. So if you are in manufacturing, you're not really regulated. But if you operate in the banking sector or the insurance sector, you are regulated. And those sectors, what they require is that before you become registered as a bank or an insurance company, you must first register as a company in terms of the Companies Act. So you must first be a company, then you must apply for a license from the regulators, and you become a regulated entity. But even those laws, they did not say anything about climate change when they were first promulgated. I mean, the Financial Sector Regulation Act, promulgated in 2017, said nothing about climate change. And the regulators issued various prudential standards that apply to insurance companies and banks. And at the time, they said nothing about climate change. And they were issuing those standards in terms of the statute that regulates. They mentioned various risks like IT, fraud, and many other risks, but they were silent on climate change. And then 2022 happened, the floods in Durban. And then suddenly, our regulators woke up, issued various notices to banks, financial institutions, and to insurers, and they said, hey, stop whatever you are doing. This is now a risk. Make sure you take it into account. Make sure you provide for it. We also know what happened in 2024 from Parliament's perspective. For the first time in South Africa, we have legislation that is specific to climate change. Yes, we've had NEMA dating back many years, but that dealt with different issues and responsibility of everybody in general to look after the environment. And that came from the Constitution and what it provides for in terms of people having a safe and healthy environment, clean air, clean water, and all of those things. So it was all about anti-pollution. Since 2022, Parliament has woken up, our regulators have woken up, and they say climate change is now a risk. And we demand that directors of companies must now ensure that they take it seriously and talk about it, formulate policies on it, and mitigate the risk. Why? Because obviously in financial services, there could be systemic risk. Impact could be bigger than just that institution. Because as you know, in financial services, when one institution fails, it can have domino effect. So I'm just giving you that introduction. I'm going to start by greeting you and thanking the Center for Environmental Rights, Institute of Directors of South Africa, their stakeholders, their backers. We know they cannot operate without their backers, so we acknowledge all those people, and we thank you for the opportunity to allow us to participate in this study and to start and participate in the debate on liability of directors. I would like to acknowledge especially my colleagues, Nazreen, Atlanta SC, Nicola, who's here with me today for moral support, Kanya Kanyiso Gwaza. We worked on this opinion, I think, for about 3 months, and it represents our best effort. But let me say this, because it is a written document, it is a living document. Just this morning, we were having debates amongst ourselves as I was preparing my slide presentation. And some things occurred to us and we said, hey, maybe we should update the opinion. Maybe we should add something more to the opinion. Maybe we should have a section dealing specifically with regulated institutions such as financial services. Because the approach we took when we prepared the opinion was we looked at companies in general. We did not isolate institutions or sectors and say, in this sector, this is how it works. In this sector, this is how it works. What we did is we looked at companies in general, companies that are registered in terms of the Companies Act and are regulated in terms of South African law. And that was the approach we adopted in the opinion. As far as disclaimers are concerned, I've already said it is not sector specific, the opinion. It answers the general question and it reflects our collective views as the legal team. As you know, it's like 5 judges sitting in the Supreme Court of Appeal. Usually they will debate a matter and sometimes they don't always agree. They have to persuade each other, and at the end of the day, what you will usually see is a consensus judgment. Sometimes they are not able to persuade each other, and you often find that there's a dissenting view which is reflected in the judgment. But when we prepare the opinion, we tried as much as possible to reach consensus on certain issues and to even persuade each other where one or the other person was not persuaded. The opinion is to be used for engagement, is very important, for education, advocacy, debate, and discussion among stakeholders. And let me be clear, we welcome criticism. We welcome debate because we are human beings. It's not the Bible. Even the Bible, we still criticize, as you know, some parts of it that we don't agree with, we still ask questions. So we hope as we go along, we will refine it when new information becomes available or when new cases come to light. So this is our offer to the Institute of Directors and CAR that we are available. If something new comes along on the subject, we are willing and able to adapt the opinion. Now, I'm in slide 5. I operate mainly in the financial services space, and that space is well regulated. This is where banks, insurance companies, asset managers, investment managers, you name them, they operate in that space. But they are all companies. So the law relating to companies applies as much to them as it applies to Foschini Group, which essentially sells clothes and operates largely from shopping malls, and that's their core business. They are companies. In the pension space, for example, we've had Regulation 28, and we have had it for many years. And Regulation 28 says boards of pension funds being trustees, when they invest assets of a pension fund, they must take into account climate issues and how it impacts on the fund. Now, in one of the largest funds in South Africa, I've been sitting as a trustee for more than 15 years. Yes, we heard about climate change. We knew about it, but it was only in 2024 that we adopted our climate change policy. So that just gives you an idea that, until something gets closer to home, we don't really take it seriously. We see it as something very far away, something that happens in the movies or something that affects the rich countries in Europe and America and maybe Asia. Only this year did we sit down and say, hey, the law requires that we must do this. Let's sit down and have a look at it. Why am I mentioning that? Because for most companies in South Africa, it's the same story. People have heard about droughts, they've heard about flooding. Until it gets closer to home, nobody really takes it seriously. Nobody says, hey, let me have a look at it. Let me see what is it that I'm required to do. So those companies that do not operate in regulated environments, I can assure you many of them have not taken a stance on climate change. And by stance, we mean this: acknowledge that it is a risk, acknowledge that it is there, determine to what extent it may impact you as a company, and then decide what mitigation steps you should take. Because remember, companies operate in various sectors. One sector may not be affected the same way as others. It may be the issue of materiality for some people. It may even be, if my risk appetite is such that I can tolerate this risk and live with it, and you do that, but at least they must take a stance. And that is the position we adopt in the opinion. In slide 6, I give you just a few examples of the regulated industries. As I mentioned, there's a prudential standard, GOI 3, issued in July 2018. It dealt with insurance companies specifically. And GOI, for those who are not familiar with the insurance industry, it is governance and operational standards for insurers. So these are legally binding documents issued by the regulators in terms of the Financial Sector Regulation Act. And that act in section 6 says whenever statute or regulators impose an obligation on a financial institution, the directors of that institution are responsible for ensuring that the institution complies. And the consequence is that if they don't comply, then they are the ones that are in trouble and not the institution. So what this standard said is that an insurer must have a board-approved enterprise-wide risk management system consisting of risk management strategy, policies, procedures, and tools to assess, monitor, report, and mitigate material risks. That's what it is all about. So that's what boards generally are expected to do. As I said, this was in 2018. What this standard does, it lists 11 risks that may impact insurance companies, and it was silent on climate risk. It did not mention it. The guidance note issued there was first a communication issued in August 2022 after the floods in KZN. For the first time, the regulator said, banks, insurance companies, financial institutions that are regulated by us, look at climate change. It's now a problem. Have a look at it. And I will share that document with the CR team, and maybe in the panel discussion, you can delve deep into it. In the interest of time, I won't cover it in detail. In May 2024, there was a guidance notice 1 of 2024 issued by the Prudential Authority. And this is what it says. Climate change may result in physical and transition risk that could affect the safety and soundness of insurers and have broader financial stability implications for the financial sector as a whole. So for everybody, because I can assure you, all of you sitting here, most of you have a car, most of you have a house, and you want the person you've insured those properties with to be financially sound. Because if something wrong happens, you want them to, come good and pay your claim. So their financial soundness and the stability of the sector in general depends very much on mitigation of risk. So it concludes by saying, to this effect, it is imperative that insurers take active steps to address climate-related risk. What do we learn from this? We learn that the regulators have now become aware of climate risk, are instructing those institutions that they regulate to also be aware of climate risk, and take appropriate action to deal with climate risk. So in the regulated space, we are on a good wicket. And I can safely say that, relative to our international peers, we are there. One thing you can say about our financial services regulators, they are rated amongst the best in the world. So they're very up to date when it comes to what international trends are. In the regulated space, even appointment of directors is regulated. You are a key person and you must be approved by the regulators in order to be appointed as a director and operate as a director. And consequences are, if you don't comply with legislation and these directives from the regulators, you can be removed, you can be declared not fit and proper. Regulatory penalties can be imposed that affect you directly. And in South Africa, if you've been declared by one regulator as not fit and proper, chances are you cannot serve as a director somewhere else. So liability is not just about damages being paid. It's also about being held accountable, meaning you are debarred, you are stopped from ever acting as a director or key person again, or you have to pay huge penalties. So let's not look at liability always as you are taken to court and you are sued and there's a judgment against you and a finding of guilt. Sometimes it can be regulatory action by the regulators affecting the directors directly. As we said, our opinion does not focus on regulated industries as the position is fairly straightforward there, but we are willing to update it to have a specific section dealing with regulated industries. Our opinion dealt with directors of companies in general. Now, the next slide captures what I just said a moment ago, what liability is. Liability is about accountability, about responsibility, about being answerable, about being compelled to make satisfaction, compensation, or restitution. So when we talk about liability of directors, it's all of those things together. It's not one thing or the other, it's all of them together. And I've just referred to one of the earlier appellate division judgments where the appellate division, as it then was, dealt with what we mean when we say liability. Now, in South African law, as you know, companies are legal entities. So the general position is if on climate matters, the company did something wrong, it is the company that will be sued by third parties. That's how it works. The company will be in trouble with the regulators. The company will be prosecuted if what they have done constitutes a criminal offense. And as you've seen with BP and many other recent cases that involve the environment, it is the company that will be taken to court, not necessarily individual directors. Because we have this doctrine that in South Africa, once a company is registered, it is a legal person in its own right. Directors are simply an organ through which the company functions. So as a general rule, if the directors are acting in that capacity and there's a loss caused to third parties or there's a breach of statute, it is a company that is liable, even on climate-related matters. But what if the loss is caused to the company itself? Can directors in that situation be held accountable? So I want to touch on, before I deal with the private sector, with the public sector. The Climate Change Act, Act 22 of 2004. Very interesting. When I started with the introduction, I said, Parliament has recognized now that climate change is a risk. The preamble to the Climate Change Act, I've quoted only 2 passages in the preamble. And it says, climate change represents an urgent threat to human societies and the planet and requires effective, progressive, and incremental response. It goes on to say, climate variability in South Africa specifically, including increased frequency and intensity of extreme weather events, will affect, amongst others, human health, access to food. So these are constitutional rights. Water, biodiversity habitats, and ecosystems, the coast and coastal infrastructure. So Parliament finally recognizes that climate change is a risk to South Africa. and it will impact human rights that are contained in the Constitution. But the Climate Change Act does not apply to you and me. So it says nothing about you, it says nothing about me. One of the sections in that act is section 7. This is what it says. Every organ of state that is affected by climate change, I emphasize that. They don't say all organs of state. As you know, SASA pays SASA grants. So to them, climate change is not an issue. They get money from Treasury, they distribute grants, that's the end of their business. But if you are Transnet or you are Portnet or you are Eskom, climate change is an issue to you because Eskom burns coal, they burn diesel. Transnet and other state entities, they operate near the ocean where they store goods or they deliver goods or they do all sorts of things. If there's flooding, they are affected. That's why Section 7 says every organ of state that is affected by climate change, not all organs of state, must review, this is important, and if necessary, revise, amend, coordinate, and harmonize their policies, measures, and programs and decisions in order to ensure that the risks of climate change impact and associated vulnerabilities are taken into consideration. So Parliament finally gets it, and this is now the law. Why I deal with Climate Change Act? Because we're talking about companies and directors, and state-owned companies have directors, because remember, they are companies registered in terms of the Companies Act. And if you are familiar with the Companies Act and how it works and state-owned companies, there's also an animal called the PFMA. And somewhere in the PFMA, it says these are the accounting authorities of the company. It is the board of directors. And there's a section, I think it's chapter 3, if not chapter 6 of the PFMA, that says the accounting authority is responsible for ensuring that the SOC complies with all the laws. So this is how the directors of SOCs can become liable, because the PFMA will then require that they comply with Section 7 of the Climate Change Act. And there will be consequences in the PFMA if they don't comply with applicable laws. So there is your liability, which arises from statute, but it's in a roundabout way because you have to look at different acts to get to what the answer is. And that's just public sector. Now, what are the takeaways from what we've heard so far? Parliament finally recognizes and acknowledges that climate change is a risk and a threat to government's developmental goals, but also constitutional rights of you and I, our right to clean water, our right to a healthy environment, the future of our children. And Parliament directs organs of state to take seriously and take appropriate steps. And as I said, there could be consequences under this statute, but also under the PFMA. I don't want to deal much with NEMA because under NEMA, which is the National Environmental Management Act, we covered it in the opinion because we wanted to be as broad as possible. But NEMA imposes obligation on companies to comply with environmental laws. And there are offenses if companies do not comply with environmental laws. And in Section 34, sub 7 specifically, it imposes liability on individual directors and individual employees of companies that breach that statute. So for example, it says any person who is or was a director of the firm at the time of the commission of that offense shall be guilty of an offense and shall be liable on conviction for penalty. So this is one of the statutes that impose liability and consequences for directors and senior management employees of companies that breach this statute. What of private sector generally? If I run a shoe store from Sentin City Mall and I've registered that business as a company, and I'm a director of that company, or it's a family business or just a small business, what does climate change mean to us? As long as our goods and services are delivered to us on time and we sell our goods and services and we make money, Why should we be concerned about climate change? Does the law impose an obligation on us in such a situation to care about climate change? The Companies Act itself does not. And that's the view we hold, and that's the view we express in the opinion. What the Companies Act does, though, it says in Section 66 that the business and affairs of a company must, and I emphasize that, must be managed. I've highlighted the word managed. I'll come to it in a moment. Must be managed by or under the direction of its board, which has the authority to exercise all the powers and to perform all the functions of the company, right? The approach our financial services regulators have taken is that management entails also managing risk, and risk includes climate change risk. Section 76 also of the Companies Act imposes fiduciary duties on directors, and it says when directors exercise that power that you see in Section 66 or perform those functions as directors, they must act in good faith for a proper purpose, in the best interest of the company, with the appropriate degree of skill, care, and diligence that can be expected of a person who is in that position. Right? That's what it says. So skill, care, due diligence for a proper purpose in good faith, the best interests of the company. Generally, what are the best interests of the company? It must do well, must make profit, must not suffer a loss. So how do you ensure that a company does not suffer a loss? Well, it must sell its products. If it's impacted by climate change, then it cannot sell its products. You know, if it gets bad reputation because it engages in activities that affect the climate, that's a problem. So we say it is arguable there that if you don't do any of those things and you don't take climate change into account, you're breaching your fiduciary duties. Very important, Section 76, 4 and 5 of the Companies Act accepts that we are all human beings and human beings make mistakes. So what you are expected to do, I mean, I've been a trustee for close to 20 years, and I look after hundreds of billions of rands. And I can guarantee you, I've made some investment decisions that have not turned out as I had hoped. I have made decisions that, with the benefit of hindsight, I should not have made. But there's an interesting judgment from New Zealand many years ago where a court said, one must never use hindsight to impute foresight. When you judge somebody, you judge them on the standard of a reasonable person. What would a reasonable person in that position, armed with proper information, would have done? And that's really the standard you see in the Companies Act and the business judgment rule, because what it really says is that a director would have satisfied his obligations if he has taken diligent steps to become informed of the matter. Now, in the context of climate change, you must be informed of climate change and the risks that it may bring about, and you must decide what you're going to do about it. So if you have informed yourself of the matter and you have made a decision because you believe that the decision was in the best interest of the company, so that is the standard set by Parliament. Or if you have taken advice of professional persons retained by the company as to matters involving skill or expertise that the director reasonably believes are matters within that person's expertise. We said in the opinion, we're not climate change experts, and we are neither alarmists nor skeptics. We are somewhere in the middle. There's enough evidence for us to believe that it is there. We don't know what its impact is, but we are prepared to accept if the experts tell us that it is there, that it may have impact. And that's the approach we have taken. And we say that is what is expected of directors. You cannot hear all these things or see what just happened in September, at the end of September, when trucks were stuck in KZN because there were snow conditions that prevented people from moving, and say that's business as usual. that does not affect me. So the evidence is there for us to see the impact of it. That's what we don't know. Now, coming to the obligation in section 66, management, as I said, this is how our regulators who have already interpreted the section look at it. They say management entails organization and coordination of activities of a business in order to achieve its objectives. And managing risk is an essential component of management. So you cannot say you are managing, but ignoring risk. They go hand in hand. If you are managing, then you need to also manage risk. And they say risk management is a process of identifying, assessing, controlling threats to the organization's capital, earnings, and operations. It's usually those three things. So in our view, we say the power and obligation that you see in section 66 that Parliament imposes on directors to manage the company's affairs includes the obligation to manage risk. So that is our opinion. And we say this includes the risk associated with climate change. The power must be exercised in good faith with the necessary care, diligence, and skill, and in the best interest of the company. And the view we hold is that failure to exercise this power properly may result in liability for directors. What that will look like, we don't know yet, because as you know, these things must still be tested in a court of law. Where we are now is simply an academic research similar to a textbook. So many of you who've written textbooks or written academic articles know that until it is tested in a court of law and the court agrees with you, all it is an opinion. And sometimes courts differ even amongst themselves. You find a similar issue going to 4 different courts. In the High Court, the one court rules this way. It goes to the full court, it rules another. It goes to the Supreme Court of Appeal, it rules another way, until it gets to the apex court where you get finality. But even then, it's finality because there's no further appeal. I'm sure if there was further appeal, people would still debate those issues. So what we say about climate change as a risk, I'm in slide 18, is that as the Climate Change Act itself shows, not every sector will be affected the same way. That act says organs of states affected by, so not all organs of states. In the private sector, it will be the same. It will be those that are mostly affected by climate change that will be required to act. It will not be everybody. What at the very least is required is for all directors to look at it and say, is this an issue for us? If it's not an issue, why is it not an issue, and leave it there? So that if you have to account, you are able to say, we looked at it, we assessed it, we were of the view that it was not a risk to us. Now, on limitation of liability, as we said, we take the view that the directors who ignore the risk and ignore the advice given to them can be held liable should the risk materialize. Because remember, if there's a risk but it never materializes, we are all happy. But if it does materialize, the company suffers a loss, they can be held liable. And remember, they can also be held liable by the regulators and other people. So it's not just limited to loss to the company. We also take the view that a director will be protected from liability if they exercise proper judgment in terms of the business judgment rule. On the issue of standing being locus standi. So if you were a shareholder or you were a third party and you were aggrieved or unhappy that directors did not take into account climate change and there was a loss either to a company or to third parties, in the opinion, we deal with the issue of who has legal standing to take the directors to court. So we have covered that. We also deal with circumstances under which shareholders and interest parties may do so, bearing in mind, of course, that if the company has suffered a loss, it's usually the company's loss and not the third party's loss. There's a law on that. There are complex SCA judgments that we have covered in the judgment. There was one recently in April or May this year. If I had to talk about that judgment, it would take me 2 hours. So in the interest of time, I won't deal with it, but they are covered in the opinion. So in summary, we emphasize that the law is still in its infancy when it comes to liability of directors in relation to climate-related issues. That's the general position. Remember, on regulated industries, we are miles ahead. What has not happened in that space, as far as I know, and I sit, as I said, in the appeal tribunal, no director has been held personally liable for climate-related issue. But the law is already there. It is possible that they can be held liable. It's just that there has not been a case yet where that has happened that I'm aware of. So we say the law is still in its infancy. We don't know where it will go. We don't know how the courts will develop our common law to take it to where it wants to go. But interestingly, when you look at many of the judgments involving companies and directors, our courts are now looking at the King report. And they are saying that is the conduct expected of directors. So apart from what statutes say, they now say, this is now generally accepted that when you are a director, you must do those things that the King report said must be done. So you can no longer as a director say, I've opted out of King. I've looked at it, I've opted out. It doesn't concern me. Whatever they say is irrelevant. Courts are now quoting it directly. And when a director has not done what they are supposed to do, the court says you have acted improperly because you have not complied with the standards set out in the King report. So already we are there. And if you look at what the regulatory authorities in the financial sector have done, they've taken all the warnings in the King report in 2016, and they have incorporated into some of the regulatory instruments. And you've also seen the language they use is the language that is used internationally, even in some of the articles that were prepared by the Institute of Directors, the JSE listing requirements, all of those, they have now incorporated into regulations. So it's almost like everybody's now singing from the same hymn as far as climate change is concerned and what is expected of directors. So we are saying in bullet 2 that South African law is moving in the right direction, both parliament and regulators, standard setting bodies being the likes of JSE, and that they are boldly adapting directors' duties to incorporate good governance principles that everybody has been talking about, but they are not specifically legislated. And it is only a matter of time before an appropriate case comes before the court, and courts can finally decide that in these circumstances, directors will be liable. And we wait for that. So that is my presentation. Thank you very much.
Thank you so much, Advocate. We're very
Did I
happy
stick to
have
the
you.
time?
You stuck to your time. However, I don't know if we're going to have enough time for questions.
All right.
Yeah, and I know you have.
I've got another 20 minutes or so.
Okay.
Because I'm driving to Alexander Forbes. I should be there before 2. So.
All right, wonderful. Should we maybe start in the room? Do we have any questions for our advocate? Questions, comments, debate?
Thank you very much and good afternoon. I think that was very, very insightful for somebody who's not in the legal profession, at least. You simplified it a lot for me. But just coming back to the issue, various boards have various committees and subcommittees. What is the feasibility or the practicality of now enforcing ESG committees within the various boards, environmental, sustainability and governance into the various boards?
I think the principle that you pick up, especially from GOI 3, I must tell you, GOI 3 deals with risk management in general. They make it clear that the board can delegate to the audit committee, for example, or the risk committee, but the ultimate responsibility lies with the board. So if something goes wrong, the regulators won't go to a subcommittee. They will go to the board and say, what did you do? So it's the issue of you can delegate, but you cannot abdicate. The responsibility lies with the board. But as you know, boards are busy with so many things. So in the conduct standards themselves, they actually say you must have subcommittees. And the subcommittees must have people who are appropriately qualified, even if it's external people. And you must rely on advice because you cannot be an expert on anything. So they take all of that into account, but they say you cannot abdicate to those advisors or to those subcommittees. The ultimate responsibility lies with the board. So the regulators have made that very clear. And some of the statutory instruments make it very clear that if something goes wrong, it is not the subcommittees or the employees that are responsible. Even if you are the head of risk in a company, when something goes wrong, the regulators won't look to the head of risk, they will go to the board because that is the organ that is ultimately responsible. How they delegate is up to them, but the buck stops with them. So that's usually how it is regulated.
Thank you very much, Andy. Oh, that's very clear and interesting. In talking about, sorry, my name is Richard Callett. In talking about the reasonable director making a decision in a particular point, you used a phrase, armed with, not you said right or armed with. It seems to me that could turn out to be very important for emphasis. And the reason I ask that, I'm going to do that really annoying Madam Chair, who uses a question to them and talk about their own stuff. I apologise. I'm going to do so anyway, briefly, because it is relevant. I lead the board leadership against the Cambridge Institute of Sustainability Initiative. Alongside our work with boards the last 2 years, in partnership with DLA Piper, we've done some research about global standard reflection. That's why I'm so interested in this session today on this report. Our latest review, the latest, which I've just peer reviewed with others, deals with this point. It deals with the question of what information the board has before it when it makes decisions, when it directs and oversees and is liable, legally liable for the conduct of the company. And it's really a very interesting question in an age, of course, of fake news and so on. And my experience of one board recently, where clearly concern was that one director was relying on information, let's say dubious standing and credibility to influence their attitude to certain things. So I wonder if you agree with what I'm suggesting about this, and how should boards then go about ensuring that they do have the right information? Who's the manager of that, and who's the guardian? And can they simply say we'll rely on what the executive of the company tells us? Or should they be finding alternative sources of information in which to, in a sense, test the ground and make even better decisions?
If let's go back to that test, and you find it in section 76. It says you have satisfied your obligations as a director if you have taken reasonably diligent steps to become informed about the matter. So if you were diligent, you're quite right, you can't just accept everything. So if the information comes to you, you say, what is the source of this information? But it also continues to say, you are entitled to rely on advice of professionals, including employees, senior employees in the company who are working on a particular matter. I mean, take an example of HR matters. The board won't be aware of HR matters because they operate at a different level, but there could be a manager that the employee reports to. So if the board relies on information it obtained from the manager, there's reasonable certainty that, that information is correct. It may turn out to be incorrect, you're quite right. But if the board says, this is the reporting line, this is the employee's manager, this is the information he gave us that the employee arrived to work drunk or was absent from work for 5 days, and this is the timesheet or clocking sheet. If you are a director, you can, reasonably say that seems accurate. But if you are told that here is information, we don't know where it comes from, but we trust that it is correct, then that becomes a problem. So the standard is really that you've taken diligent steps, and it will be assessed on a case-by-case basis. You can't say generally you are diligent if you do ABC. It's similar to, driving a car. You would know that, when you get to a stop sign, and depending on circumstances, there are times when you have to stop because traffic lights are not working, or there's an elderly lady who's crossing the road, even if it's green in your favor, all of those things. So it's all about, in the particular circumstances, in the specific case, did you take diligent steps to rely on that information? And in the age of AI, I mean, you would have seen with the elections happening in the US, there are some videos depicting Kamala Harris and Donald Trump dancing together. And AI is so advanced that, I mean, when you look at it for the first time, it looks legit. But the more you apply your mind to it, the more you realize that these are sworn enemies. This cannot be a legit video. So the test is really that did you take diligent steps to satisfy yourself that the information is accurate? And if you've done that and it turns out not to be accurate, it goes back to what I said. You cannot use hindsight to impute foresight.
I hope to not open a can of worms. Are organs of state-owned companies?
Introduce yourself, Zoe.
Mohammed Lockett, Chief Counsel.
So remember, not all organs of state are companies. Usually when you are a state-owned company, your name will say so. Eskom SOC Limited, so-and-so SOC Limited. You have other organs of states that are just institutions established by statute. Others are established by government departments to carry out government's work, but not all of them are state-owned companies. To be a state-owned company, you must be registered as a company, and your name will reflect that you are a state-owned company, and it will usually say limited at the end.
So Chapter 7, the Climate Change Act, refers to organs of state, as you mentioned.
Yes.
And you referred to Eskom
Yeah.
and Transnet.
Yeah.
What's the distinction?
So the term organ of state is defined in the Constitution. If I'm not mistaken, it's 239 of the Constitution. And there's several judgments where the courts go into detail about what is and is not an organ of state. And I made an example, something like SASA would be organ of state because, I mean, it's controlled by the state. I'm involved in a case, it's still before the court, so I won't say a lot about it, where the question is the National Lotteries Board an organ of state? And that's one of the interesting debates we'll have in court, probably in 2025, because, there are factors that you take into account. Other people say it's not because it doesn't receive funding from the state and whatnot. But there are those various issues. So it depends. But state-owned companies are organs of state and they are required to comply with the law. And there's actually a constitutional court judgment dealing with that, if not SCA, constitutional court. Yeah. So that section 7, when it says organs of state, it is organs of state as defined in the Constitution. Everybody who's covered by that section in the Constitution have an obligation in terms of that section to take those steps. And I'm hoping in the near future, we will get actually regulations from the minister responsible for that statute, clarifying some of the issues raised in the statute. And as far as I know, the effective date of that statute has not been determined. I'm not sure. It was signed by the president, but when it actually comes into effect, I don't think that has been determined yet. The last time I checked, it was not determined. But you can see that Parliament is there, President is there. They recognize this thing as an issue. They appreciate the consequences of climate change. They're imposing an obligation on organs of state to change their ways to ensure that climate change does not become an issue, or if it is an issue, there's at least mitigation of risk. Yeah.
I think we have one more
Sandy,
question.
before we go to the next question in the room, well, maybe to address that question on the Climate Change Act, Presidential Climate Commission recently said in a briefing that regulations need to be made and that could take up to 2 years. So that's the latest information we have on that. So we do have some questions online. So one of the questions which I think would be easier to answer is, does the legal opinion also consider the implications of the Climate Change Act for private companies and not just of organs of state, given that the Climate Change Act extends to the private sector through the carbon budget system and imposition of the SET's sectoral emission targets? And then and a different question relates to the application of double materiality. And essentially, Dalit Ansi is asking about, the double materiality approach. And so, she takes the point that some organs of state and companies are more affected. But, if there's a tendency for the less obvious actors to sit back, that becomes quite dangerous. So what are your views on that? And then we'll take the question.
I mean, the second one is very interesting, because it's not really legal view. It's what your views are as a person generally. And I tend to agree with what the person has said. But every time you start something, you start from somewhere. And, other people say you start with the low-hanging fruit, because that's usually where the problem is. And as you continue, you deal with everybody else. And that's usually how regulation operates. I mean, in every sector, government always tries to make example with the big boys, because if the big boys set an example, then it will cascade downwards and everybody will sort of comply. That's at least the idea. Whether that works in practice, I cannot say, but I fully agree with the question from the speaker, the person who asked the question. Leanne, the first question, what was it? It was about whether we've considered the Climate Change Act and how it impacts.
Whether we've considered the implications of the Climate Change Act for private companies.
Yeah, we've dealt with it briefly in the opinion. We did not go into great detail. So I think we touched on a couple of sections in the Climate Change Act. And the extent to which, they affect everybody generally. Because I think the opinion is 80 pages long. We could write up to 500. To be honest with you, we could write even up to 1,000, but then it just becomes a long thing that does not have structure. So what we've tried to do is to break it down into sections, as I did with my presentation. I try to include state-owned companies, how they can be impacted, independent of what the Companies Act says. There's this statute, and then financial services, this is how they can be affected, and then companies generally. If we had to cover each and every section of the Climate Change Act, we could have written a 300-page opinion. We would not have finished, I think, Nick. We would still be at it now. Because I read it again, even yesterday, I read the Climate Change Act twice as I was preparing the slide presentation. There's a lot more that can be said that we did not say. That's why I said in the intro, our offer is, as the area develops, as the debates become more and more in the open, as more regulators issue documents, as cases come before the court, we will continuously adapt the opinions. So we will be like King. There'll be King 1, King 2, King 3, King 4. Our opinion will be 1, 2, 3, 4. And we will always put a date to say when it was last updated, so that you know that it reflects the law as at a particular date.
Thank you, Sandy. We'll go to the room and then we have one last question online.
Thank you. Thank you for your address, Essie. It was very interesting. My name is Nicola Irving. I'm an associate in the Public Interest Department at Norton Rose Fulbright.
Okay.
And my question is, it's probably something that's more appropriate for an adjudicator to deal with in a context-specific situation. But I'd just be interested to hear your thoughts on the relationship between the precautionary principle and the business judgment rule, and kind of the standard of the reasonable director, because it seems that there's, the subjective and objective component to the reasonableness of decision making. And obviously the overarching principle, the precautionary principle. So I'd just be interested to hear your preliminary thoughts on that.
That's why when you do opinions like this, you must always have a disclaimer. Because even the question you are asking, it will very much be fact specific. I was talking to Leanne just before the session started. as you know, state-owned companies, for example, have shareholders compact. Prof, you would know, with the minister involved or the government department that deals with that specific issue. And if you take an example of Transnet or Eskom, if the agreement for 2024 was, I don't want to see any load shedding, do everything you can to make sure that there's no load shedding. How do you balance that with your climate change obligations? You're going to burn as much coal as possible. You're going to burn as much diesel as possible. And if that director is ever called to account, not by the minister, but by NGOs or by third parties, and they go to an annual general meeting and say, why are you burning so much coal? Are you not aware that you have these obligations and that obligation? You put him in a position where this question must now be answered, because he will say, acting as a reasonable director, I appreciated that I had to balance various interests. One of them was ensuring that, I comply with climate change obligations, but I also keep the lights on and I do these other things. So that's why it is so difficult. I mean, it will be interesting, especially those specific sectors, if they were ever taken to task, or if we could even hear from them, if they could come to the public and present to us and tell us how they balance, the various obligations, because there seems to be a clash. Obviously, there's a clash, and you must find the right balance, and you must determine whether in the specific case they've acted reasonably. And it's a tough task. Yeah.
Sanila, I know you've got to go. So the last question online is section 34.7 of NEMA was quoted as having been considered in the opinion, which requires a failure to take reasonable measures as a basis for liability. So the person is asking whether you considered section 24N8 of NEMA, which seems to introduce strict liability for directors.
I can't seem to recall, Nick, section 20?
Section 24 to N. Yes. So, sorry, section 24N8 of NEMA. So I don't think we considered the strict liability issue under NEMA.
Directors, we do touch on it briefly. I think it does feature or is that not what senior counsel referred to earlier?
No, so section 37.4 says if the offense in question resulted from the failure to take reasonable steps. So the earlier section deals with strict liability, where you're liable simply because something happened and they don't look at whether you took reasonable steps or not.
Oh, that's the delict that's in the statutory delict.
Yeah.
And so is the question
whether we considered it in the opinion.
So that section 24 refers to the company specifically, right? Not the director.
It says strict liability for directors.
I think we will, maybe we'll have a look at that. My recollection is that we looked at it. I don't know if we've specifically addressed it in the opinion. So I'll make a note of it, and then I think we will look at it. As I said, we've already offered to maybe add a section on regulated entities. So it may be that this is one of the issues that we can update and just add. Because
maybe one thing to add, what we're looking for is room where not necessarily there is a violation of provision of the Act, because that may be quite, or one of the more regulatory provisions that require permits, this or that. But we're looking at the two violations, the two provisions that just speak about general harm to the environment and whether those can be used. So some more general provisions and whether it can be a violation of those sections, whereas and then how you can get liability under those as opposed to for specific, violating a permit or authorization.
Okay. Fantastic. Those are all the questions online.
Fantastic. Thank you. Thank you so much, Advocate, for being with us. And yeah, we can now release you onto your next appointment, but thank you so much for being with us.
I'm going to have a beer at 5 o'clock today. Once I'm done with that AGM, as you can imagine, two-pot system and its implications. So I have a legal presentation on that, which is, yeah. Anyway, thank you for having me and good luck. Leanne, as I said, we're always available to help. And where we need to make updates based on the questions that have arisen, I think they're important questions. Maybe we will just update the opinion. And Nick, I think you're staying behind Nick, so the heat, you'll take the heat after I'm gone and cover the rest of it. But thank you. I hope to see you soon.
Thank you very much. Okay, just to flag, we are running over time. So we'll try our best to catch up as we can. We're now going to move on to the presentation of findings by Leanne, Gobinsamy, and Zara Omar. I'm just going to give a brief introduction, and as I said, in the interest of time, you can catch up on the rest of the amazing things they've done. Leanne Gobinsamy and Zara Omar are attorneys at the Center for Environmental Rights. They work in the Center's Corporate Accountability and Transparency Program, which works towards challenging institutions of power in order to advance transparency and environmental and climate justice. So now I'll hand over to Leanne.
Thanks so much, Ananta. And thank you all for bearing with us. It's a bit of a long presentation. The first thing I'd like to say is that Sandile has covered a lot of what I was hoping to cover in this initial section. But what I will do is try to go into a little bit more of the details of the opinion. Also just recognizing, at the CER, we are lawyers who are also activists. And so we will have people online from a wide variety of different sectors, wide variety of stakeholders. So if some of this sounds repetitive, please excuse us. We're speaking to a wide audience. Well, the first thing, and Sandile has also referred to this, right? We're quite aware of the impacts of climate change, rising sea levels, extreme weather events, droughts and floods, massive biodiversity loss, having an impact on all facets of society, right? So global systems and value chains, supply chains are under threat, and companies are finding themselves in an increasingly risky and challenging environment, requiring large-scale and often expensive shifts away from fossil fuels. And so one of the questions, I'd like to raise in your minds is, Sandile has spoken about a duty to take certain measures, is it reasonable, etc. But we find ourselves in dealing with a lot of the fossil fuel companies asking the question of what is the nature and the pace of the transition that is required in order to address the level of risk. And I think that's quite significant because what we're looking at here, and we deal as shareholder activists, we attend the annual general meetings for Sasol, ArcelorMittal, Renergen, which is a gas extraction company. We're dealing with those issues all the time, bringing these issues to their attention. And often the tricky issues are related to the urgency and the scale of the ambition that is required. So as weather events become more severe, droughts becomes more severe. Southern Africa, according to an IPCC report, is on track to become much warmer, much drier. What is the scale of the ambition that is required, and what is the urgency? So again, we're all quite aware of South Africa's dependence on coal-fired power. That has locked in a huge part of the economy into greenhouse gas intensive assets that will become stranded. And so, this is all taking place, this discussion, if any of us need a reminder, is taking place in the context of a just energy transition in South Africa. That is also requiring companies to think much more carefully about the scale of the ambition. How do they participate in the just transition and advance certain targets much faster, given the stranded asset question as well. So we've made reference to the Climate Change Act, looking at the duties of organs of state. And I think one thing we wanted to highlight here is the necessity to revise, amend, coordinate, and harmonize policies, laws, measures, and programs. And we'll come to a section of the discussion which speaks about the duty to disclose. And again, a question to raise in the room and for those that are online is around, let's say, public finance institutions in disclosing their policies. Are they ensuring that they are harmonizing their policies in order to address some of these impacts? So to take us one step back on how do we define climate risk, right? So we're talking in this context about material financial risk to a company that arises as a result of climate change, right? And Sandile has said it depends on the size, the location, the industry, and in which the company operates, as well as its risk appetite. And we've had a conversation about this double materiality issue. So it is generally accepted then that climate change poses foreseeable risks across the short, medium, and long-term horizon. And this is made up of transition risks. So the risks associated with the transition to a lower carbon economy, which results in varying levels of financial and reputational risk. Physical risks, so risks associated with the physical impacts of climate change, such as the impacts of extreme temperature changes, weather events, etc. I think to mention in relation to physical risk, we're talking here about, and linking it to transition risks. In order to obtain capital for continued operations, companies operating in industries that face structural decline because of climate change are already being asked to prove their ability to remain resilient. And I think it's a really important question for us to ask ourselves. So how do companies then remain resilient in the face of all of this uncertainty regarding the pace of the change? Liability risks, so we're talking here about litigation or legal risks posed to companies or their directors for a breach of statutory or fiduciary duties, which is what we're engaging with here today. So what does this opinion cover? Well, this opinion is really about what does council anticipate, in their opinion, our courts will approach issues of director liability on. So how will they approach director liability for a failure to consider and manage climate risk? And climate risk here defined, as I said, as financial risk associated with climate change, such as supply chain disruptions caused by extreme weather. It explores the basis for company directors in South Africa to be held accountable under the Companies Act, the common law related legislation and good governance standards, such as King IV. Importantly, we don't consider multinational corporations, but we are limiting this discussion to the law enforced in South Africa, which binds entities and individuals incorporated and operating in South Africa. Again, to reiterate what Sandile has said, companies incorporated in South Africa are regarded as a legal person in its own right, with a separate juristic personality. But there is the concept of piercing the corporate veil, which then speaks to the directors and the shareholders as well. So director duties. What are we talking about when we talk about director duties? You're talking about common law and statutory duties, including the duty to act in the best interests of the company through exercising loyalty, good faith, due care, and diligence. And when directors fail to fulfill those duties, the company and other interested and affected parties are entitled to hold directors liable for any loss sustained as a result of their actions. So personal liability would arise where a director has breached their fiduciary duties, has acquiesced in carrying on of the company's business recklessly with gross negligence, intent to defraud any person, where a director is a party to the publication of a false or misleading financial statement, or has acted negligently, except where that negligence can be justified on the basis of an error in an honest and considered business decision. So the opinion covers, in terms of, what is the board's role in climate risk management? The opinion goes into a lot of detail on all the different sections that relate to this. Sandile has spoken about Section 66(1) of the Companies Act. So the business affairs of a company must be managed by or under the direction of a board of directors, compliance with statutory common law duties. And we will have Ansi from the King Committee speaking about the King IV and speaking about the principles in a little bit more detail, so I won't cover that. But what's crucially important here is that the nature and extent of duties, be it voluntary or mandatory guidance external to the Companies Act, has really increased over the last couple of years. And so you see some of them listed here, from the JC listings requirements, the JC climate disclosure guidance, National Treasury principles and guidance for minimum disclosure climate-related risks, NEMA, and the Climate Change Act. And so we have to pay attention to all these shifts and ask ourselves how these shifts are creating additional risk and creating additional scope for courts to consider what reasonable measures are when directors breach their fiduciary duties or claim a defense to the breach of a fiduciary duty in raising, let's say, the business judgment rule. So again, I'm not going to go into a lot of detail here as we are running over time, but I do have on the slide just a summary of fiduciary duties, what they encompass, the fact that the fiduciary duties under the Companies Act is much wider than what is kind of in the statute, right? You have to consider it, and courts are considering it in the context of the King IV guidance paper, as well as Section 24 of the Constitution. So it's important to state here that what the opinion finds is that it is clearly conceivable that a director's failure to consider climate risk that pose a foreseeable and material financial risk to the business could constitute a failure to take reasonable steps, to become informed about the matter, and hence a failure to act in good faith and in the best interests of the company. And so, you know, the opinion covers the duty of care and due diligence and what the defenses are, such as the business judgment rule, which can be raised as a defense to some of these breaches. Again, here in this slide, what I'm doing here is summarizing some of the key disclosure and reporting duties. So when we talk about the board's role in climate risk management, this goes beyond just a breach of fiduciary duties, but what are they disclosing? How are they disclosing this information? And what guides the nature of that disclosure? This is quite critical information because stakeholders are requiring companies to ensure much wider, much more meaningful disclosure. Oftentimes, if we as shareholder activists in any annual general meetings, a lot of the engagement is around disclosure. And you have both local and global shifts towards ensuring much more meaningful disclosure. Most are voluntary, but I wanted to highlight one, right, which is the Company and Intellectual Property Commission kind of ESG report on IFRS. I won't get into it, but there are certain disclosure requirements that will become mandatory in the 2024-2025 financial year. And so we have to be keeping an eye out for what kind of mandatory disclosure also is required in this context. So in terms of duties under NEMA and the Climate Change Act, we have covered this, and Sandile has covered this. I think what's really critical here is that as all of these changes are taking place, you can ask a question of, well, the opinion really states that applicants, stakeholders, those willing to bring a claim in terms of the Companies Act, must be doing so in a manner that advance the interests of the company. So you're bringing a claim really to advance the interests of the company because that is the nature and extent of the breach. Right now, where we find ourselves at is that the interests of the company and broader societal interests and the interests of stakeholders are intersecting. It is no more that a corporation can say, well, we are purely looking at financial and economic risk. The financial and economic risk relates to the failure to do nothing and to delay decarbonization. And I think that's quite a critical thing for us to consider in this context. As these interests intersect and as we work out what is the extent of the risk facing a company when those interests intersect, and as claimants then are bringing a case that is in both broader societal interests as well as in the interests of a company. So I won't go to any more detail around that. I've got on the screen some additional or all the different sections that council has considered in the opinion, right? From standing to liability for loss and damage, how directors can be held liable for breaches of fiduciary duties to derivative actions. And this opinion does an incredibly good job of looking at every single section and assessing that section as and against a potential claim that could be brought. And I think it is quite important that that be broken down and that be done in a lot more detail. We simply don't have time to do that today. You know, even if you look at how these legislative provisions reinforce each other when a court is considering these matters, that's going to be quite vital. So I'm going to hand over to Zara, who will cover some of the quite interesting findings that the opinion covers on how the South African courts will approach these issues and deal with a conclusion before handing over to our fantastic panel. Sarah.
Thanks, Leanne. So as Leanne mentioned, I'll be looking at the approach of South African courts, so the existing jurisprudence in South Africa, and then also the likely approach of the courts to a climate risk scenario when it comes to directors' duties. So the South African courts have not yet had to grapple with the issue of climate risk, especially in relation to holding directors liable for such failures. But there are many cases happening around the world where, for example, NGOs are holding directors accountable, particularly criminally liable for their decisions that have contributed to climate change. And then also shareholders are holding directors and companies accountable for these failures, for failing to have proper mitigation strategies in place, and then also for overvaluing profits of the company by not properly taking into account a company's GHG emissions. So I think we can say that globally failures of ESG issues generally are being considered as failures of fiduciary duties of directors and other duties of directors. And then this is also clear from initiatives like the Task Force on Climate-Related Financial Disclosures, which some of South African reporting requirements are now becoming aligned with. And then also to say that the growing consensus on the impacts of climate change and the risks posed by those impacts, coupled with South Africa's particularly vulnerable position in relation to climate change, both from a geographical perspective, but then also from the fact that we are still quite a fossil fuel intensive country when it comes to our energy sector. And we'll need to transition much quicker to meet our climate goals. And this means that it's likely that our courts will consider climate risk to be foreseeable as a foreseeable risk, and that directors should treat it as any other foreseeable risk to a company. And then as Sandile touched on, we have the Climate Change Act. And one of the objectives of the Act is to provide for an integrated response to climate change impacts by the economy and society. And courts will no doubt start taking into account the Climate Change Act and its objectives when the Act comes into force. So when we look at South Africa's existing case law, the opinion identifies 4 trends that suggest that our courts are likely to be open to finding directors liable when it comes to a climate risk scenario. And I'll touch on these 4 trends briefly. So firstly, the Companies Act requires courts to develop the common law and to interpret the provisions of the Act in line with the spirit and the purposes of the Companies Act. Some of these purposes include to promote compliance with our Bill of Rights and also to encourage high levels of corporate governance. And our courts have relied on these specific purposes of the Companies Act when interpreting the Act's provisions, and especially the objective of encouraging high levels of corporate governance. And then as the King Principle suggests, risk management is an essential feature of corporate governance. Another important purpose of the Act is to promote compliance with the Bill of Rights, which binds both natural and juristic persons. And our Bill of Rights includes our Section 24 environmental right, which then encompasses a right to an environment that is not harmful to our health and well-being, and also a right to sustainable development, and particularly ecologically sustainable development. So what this means is that in potential future litigation, a court can expand the scope of directors' duties under the Act to include adequately addressing climate risk by relying on these particular purposes of the Companies Act and interpreting it in line with those purposes. And in fact, the courts are required to do so to develop the common law in this way. And Section 158, which is the specific section of the Companies Act that has this requirement, says the court must take into account these considerations. So, for example, the duty to act in the best interests of the company, which is a fiduciary duty of directors, when interpreted in line with our Bill of Rights, and particularly our Section 24 environmental rights, could be extended to mean that directors should now go beyond just considering profit maximization and looking at ESG factors and climate change as well. Then the second trend we've seen in the courts is that they are relying on non-binding and voluntary standards of good corporate governance, such as the King Principles, and the King Code. And they are doing so when interpreting directors' duties under the Companies Act. And in fact, the court has pronounced that these are now well-established and accepted principles, which the courts are entitled to look to, as indicating the standard which the commercial and financial world consider is reasonably to be expected of a director. So good corporate governance includes considering social and environmental factors such as climate change, as well as the financial risks that it may pose to a company. And what this suggests is that our courts will be likely to rely on the King Code, on the King Principles, and including the recently published King Guidance papers on climate change and other non-binding standards in determining what the scope of directors' duties are when it comes to climate risk. The third trend is then that our courts have relied on international obligations when interpreting our domestic laws. This is a common occurrence. Our constitution states that our courts must prefer an interpretation of our law that is in line with international law. And this is particularly important in the climate risk context when looking at South Africa's international obligations under the Paris Agreement, our NDCs, which will hopefully be updated to contain stronger targets for reducing our country's GHG emissions. And those obligations can be used by the courts to shape directors' duties. And then lastly, what our courts have shown is that there is a willingness to hold companies accountable for failing to meet their obligations in relation to the environment and climate change. This is still holding the company liable and not the director, which hasn't happened yet. But an example is the BP case, where BP was fined 53 million rand for statutory offence committed in terms of NEMA. And I'm sure we can expect similar cases being brought in terms of the statutory offences that have now been stipulated under the Climate Change Act, and especially in relation to carbon budgets for companies. Then just to conclude, so the opinion provides various avenues for holding directors liable for failures in relation to their fiduciary duties and other statutory duties. It is often for loss sustained by the company itself and not for loss sustained, for example, by shareholders or by other third parties bringing the claims. But some practical considerations for directors when thinking about this risk is then, what does it mean to adequately consider climate risk? What does it mean to assess and manage and disclose climate risk in a practical way? And some things that the opinion highlight is that, for example, when directors themselves don't have the requisite knowledge on climate risk, they should actively obtain this advice. They must ensure they have access to experts on climate risk and other ESG matters in general. And this all will fall under the duty of care, skill, and due diligence. Then directors are entitled to delegate their functions and to rely on the advice of experts, like I said, and also board committees, which was raised. An interesting thing is that fiduciary duties also apply to board committees, even though those board committee members might not serve on the board of directors. So that's something promising. But even when these duties are delegated, the director must still supervise any delegation, and this is what the opinion highlights. And then lastly, directors can't rely on any expert advice blindly. They must still exercise their own judgment at the end of the day, and a failure to do so can result in a breach of fiduciary duties in relation to climate risk. Thank you.
Thank you, Zara.
You both. I think perhaps maybe in the interest of time, Jan, if there are questions for you, Zara, we can come back.
Yes.
To that. Thank you. We're now going to move on and hear from Victoria Paxley. Victoria is an English qualified lawyer working part-time at the Commonwealth Climate Law Initiative and part-time at Paxley ESG. At CCLI, Victoria carries out legal research on the implications of climate change and biodiversity loss on corporate law, particularly in relation to directors and fiduciary duties and corporate governance in Africa. Victoria is going to give us a review of global trends and directors' duties and climate change. Alrighty.
Super. Thank you so much, Namata, and thank you so much for having us. Really, really wonderful to be here at this launch and to meet everyone as well. So if you just go back to the first slide, I'll quickly run through a few topics I'm going to talk about. So Namata's already very kindly introduced CCLI. I think that our lens is slightly different to CERs in that we carry out legal research and stakeholder engagement initiatives in a sort of analytical rather than activist way. So we come at directors and directors' duties in climate change and biodiversity loss from a slightly different lens. And then I'll have a look at two reflections that I wanted to share on this new South Africa legal opinion, and then how directors can reduce their exposure to climate-related litigation, and a few points, and it really ties in quite nicely to the conversation we've had earlier around what can directors do to make sure that they've discharged their duties in relation to climate-related risks. And then I've got a couple of points just to touch on in relation to other global trends that are happening in the nature space largely, and looking at this sort of fuller, more holistic sustainability issues rather than just focusing on climate on its own. So, Jan, do you mind jumping on to the next slide? Thank you. So I've got two reflections on the opinion, but first I just wanted to show you this slide, and I don't want to go through it in detail, but just to say that it's quite extraordinary to see the speed at which climate change has evolved from being considered an immaterial, ethical, environmental issue that is external to the company, to being now widely recognized as a presentable, foreseeable, material financial risk and opportunity to corporations over short, medium, and long-term horizons. And when I say financial materiality, because we've spoken a little bit about financial materiality, what I really mean by that is that climate change is fundamentally and economically significant information. So in other words, its omission or misstatement could reasonably be expected to influence the decision of the primary user of that information. So climate change is not a new category of risk. It is a form of financial risk that must be managed by companies in the same way that other financial risks are managed by companies. So my two reflections that I wanted to share on the South Africa opinion. The first, I think, is consistent with many of these other legal opinions on directors' duties and climate change that have been commissioned globally. And then the second is, I think, where this one differs slightly. And the first is really to talk about this point of risk. So we're talking about climate-related risks. We're not talking about compliance. So it's widely known that risk management falls squarely within directors' duties. But in many instances, climate is still being dealt with as a compliance issue by companies.
And there's a really critical difference. So compliance is something that's backwards looking. It takes existing obligations and requires you to assess whether or not a company is adhering to its obligations that are already in place. And it's often a tick box exercise. Risk management is inherently forward-looking, considering the impact of an uncertain future on corporate strategy and objectives. So because climate change is a risk and not a compliance issue, directors need to be taking a forward-looking view of the headwinds and the opportunities associated with climate change. And that requires a board to look up and out, most often by integrating diverse perspectives, which is why there is also a big movement towards diversity on boards. So that's the first one. The second reflection, which is where I think this opinion differs from other climate opinions across the world, is, and Zara, you mentioned climate nested within a full spectrum of ESG issues. And it's that recognition and the opinion that management of climate risk actually sits within a much broader set of interrelated risks, including nature and society. So it's really taking that more holistic view that I haven't seen necessarily in other opinions. So I was really interested to read that the principles of the new Climate Act include the object to provide for a coordinated and integrated response by the economy and society to climate change and its impacts in accordance with the principles of cooperative governance, and the objective to ensure a just transition. It's really critical, that bit, towards a low carbon economy. So there are a multitude of topics that sit within that provision of the Climate Change Act. And I think the King Code is really progressive in terms of thinking around these interrelated sustainability risks. And by this, I mean the climate risks, biodiversity risks, and societal risks, so that whole nexus. And I'd be really keen to hear later from the panel and also from the room on this, because there's research out there to show that climate-related strategies that don't consider the just transition as a whole pose economic and financial risks and may potentially delay or increase the cost of transitioning to net zero. So the third point I wanted to touch on was how can directors reduce their exposure to climate-related litigation? So here we're talking about the personal liability of directors rather than company liability. So first, it's just worth mentioning that if we look at cases against directors for personal mismanagement of climate risk around the world, those cases actually at the moment make up a fairly small handful of the overall total of climate-related litigation. They are really difficult cases to bring. But what is happening now, and over the last few years, is that we've seen a real growth and acceptance of the idea that climate change is going to mean a change in the way people do business, whether that's because of the transition or because of the physical risks that are manifesting here and now. But we're still seeing differences in the pace at which companies and directors are starting to respond to the shift, as well as competing views of action, of what action, if any, is required to keep ahead of this change. And there are many different steps that directors can take to reduce their exposure to climate-related litigation. That all really comes down to how those decisions are made in the boardroom. So thinking about things like, are the impacts of climate change on strategy identified, assessed, and considered by the board? Does the board take adequate advice on climate-related risks? And have board members received sufficient training to understand how climate might impact their business over different time horizons? And it's really that last point around training and capacity building that I think is absolutely critical. Have deep sympathy for boards today. They're trying to navigate a really highly complex risk landscape. It's not just climate. There are many other risks that are evolving and maturing at varying rates. But what I would say is try to remember that what we're talking about is not a new category of risks. Businesses already have financial risk frameworks in place, and climate fits into that. And in order to know what questions to ask in the boardroom, directors need to understand what climate change means for their business, so that they can critically evaluate the information that comes before them and exercise the independent judgment that they need to discharge their fiduciary duties. So there's no substitute for that capacity building piece, and some people are calling it functional fluency. And it's really being able to actively exercise that independent judgment in order to know that the information, in order to be able to critically evaluate the information you're receiving and ask questions about it. and apply their minds in the same way that other financial risks are being managed. So looking ahead, I've just touched on the idea that directors should be thinking expansively about climate risks to include nature and social risks in order to achieve effective governance. And whilst I'm not aware of a legal opinion that explores directors' duties in relation to the biodiversity, climate, society nexus as a whole, there are new legal opinions to say that nature-related risks are financially material and fall squarely within directors' duties. So, for example, earlier this year, a new legal opinion on nature-related risks and directors' duties was published by Eminent King's Counsel in the UK. And I just wanted to draw out 3 principles from that opinion that may apply to South African law, given the very similar legal frameworks that exist between UK and SA. So the first is that nature is no longer unlimited and free. Actually, take a step back. The first is that climate change is one of the 5 drivers of biodiversity loss. So biodiversity loss and climate change are very closely interconnected. Nature is no longer limited and free. So it's bringing that externality in the same way that climate is now having climate. Nature-related dependencies and impacts give rise to foreseeable material financial risks and opportunities over short, medium, and long-term horizons. And the second is that directors should be turning their minds to nature-related impacts and dependencies. So really understanding and getting to grips with their supply chains and understanding the dependencies on which their businesses run in relation to nature. So even if you're a shareholder primacist, at a minimum, it's wholly consistent with the promotion of the success of the company to consider nature-related issues through a financial risk and opportunity lens. And more broadly, consideration of relevant nature-related risks is necessary for the proper business management. And a failure by director to turn their mind to the issue is now increasingly likely to constitute a breach of duty. And that's purely from a financial lens before you look at impact. So what should directors do? And I'm going to come back to this point of functional fluency. So directors really need to start building this functional fluency and actively applying independent judgment in the same way they would do any other risks. The opinions of this particular UK one on nature-related risk actually also incorporate climate risk. So all of the points that are made by council on nature apply to climate because they're considered as a whole. So going forward, in my mind, the questions arise as to what it means for directors' duties in South Africa in relation to nature, given that South Africa is one of the biodiversity hotspots of the world that has such significant biodiversity and natural capital. It's quite interesting to think about how this climate opinion might apply to nature, and perhaps something to discuss with senior counsel in due course.
Thank you, Victoria. Thank you for that. That was very insightful. I wonder if we have any questions in the room. I am aware that Victoria does have to leave us at 2:30. So if we have any questions here, or do we have any questions online?
Because of time, we said we'll respond to questions on email.
Okay, on email. Thank you so much, Victoria. Okay, we're now going to move on to our next speaker. Nancy Ramalho is a lawyer by training and considered a leading authority on corporate governance with both theoretical and applied knowledge on the topic. And Nancy is going to be taking us through reflections on corporate governance and climate change from the King Committee. Thank you.
Thank you, and thank you for this opportunity. It's really so lovely to sit here and hear all of the different perspectives and how they come together. And so I will also echo a couple of the points that have been raised already, but probably from a different vantage point. Now, I just want to tell you a little bit about the King Committee, because there's still a bit of a misconception out there as to what the King Committee is. So when the King Committee is called a committee, it's not a misnomer. It is literally a committee with relevant stakeholders, government, the JSE, governance experts, private companies, other types of experts who all come together to draft the King codes and reports on corporate governance. The the King Committee was convened in 1993 already under the leadership of Professor Mervyn King, and issued its first report in 1994. Now, I think what is exceptional about the King journey is that from the beginning, we saw corporate governance as something much broader as the traditional understanding. King 1 followed, and I'll explain the relevance of that as we go along. So King 1 followed the definition of the Cadbury report. The Cadbury report was issued in 1993, just before the King report. And in terms of the Cadbury report and then the King report, corporate governance was defined as the system whereby which companies are directed and controlled. Now, if you think about corporate governance in terms of the system, it's really the practices, the processes, the structures, the policies, and so on that you use as levers whereby which to manage and to direct and control the company. But even in King 1, we had a much broader understanding, and we brought into it matters of ethics. We also referred to the rights of employees. You will remember at that time, South Africa was going into transition into a democracy, so it was very applicable and appropriate. And I think it's because of these historical circumstances that we were influenced in a different direction. In King 2, we progressed and we used, we didn't only talk about ethics and employees, we fleshed out ethics. And ethics is really about the triple bottom line. You know, the John Elkington concept about that there are 3 bottom lines to measure, not only the economic bottom line, but also the social and the environmental bottom line. But King Committee, as John Elkington himself has said, it's moved away from that concept because in people's minds and in companies' minds, it got perceived as 3 separate issues. So in King 3, we definitively moved away from it, and which is a subtle but important shift that I think is so often missed. We don't talk about triple bottom line anymore. We start talking about the triple context. And that's very different from the triple bottom line, because triple concept denotes the idea that the environment, society, and the economy are intertwined and interdependent in ways that can't be depicted in isolation. You need to look at all of these things together. And then in King 4, we proceeded with triple context. We made it somewhat more concrete by referring to the 6 capitals. So the 6 capitals is really just a way by which to unpack the triple context. So we're saying really that if you operate in a triple context, you make use of 6 capitals. You can slice and dice it in different ways, but you use financial capital and manufactured capital, and that's well recognized and reported on. But then you also use social and relationship capital. You use human capital. You use natural capital. So all of these, if you recognize that you operate in a triple context, all of these capitals and your dependence on them and your effects on them as a company should be recognized. And then, in fact, we moved to a definition of corporate governance from being a system to being leadership. Because to drive these things, we say you need leadership. Just to make that a little bit more concrete, you can see corporate governance as these, like I said, the practices, the processes, the structures, the policies that you have in place, all those mechanical things. But then corporate governance, the way we see it in South Africa, is really about the broader questions. So what is the role of the company in society? How does the company exercise its power? How does it need to be held accountable for its exercise of power? Should the exercise of power by companies be limited? So those are the big questions that go way beyond the traditional corporate governance domain of you need to have an audit committee consisting of 3 members, you need to have a terms of reference. It's much wider and becomes much more conceptual. And so our understanding of corporate governance, really corporate governance, is ethical and effective leadership. And yes, for effective leadership, you have to have the practices, the processes, the structures, including in them risk management. But you also have to have that overarching ethical stance, which says that as a company, we cannot be blind to our impact on society. So where we are, I think, with respect to how we think about climate change, is we're thinking about it from the perspective of the company. And that's all good and well. And this is, of course, where we are today and what we're trying to address today, because we speak to an audience of directors and they have duties to the company as such. But then I think we must be careful not to miss these broader questions, which we eventually have to move to if we want to make this work. We can't just look at this one direction as to how are things affecting the company. We need to look broader because companies are embedded in society. And society is embedded in the natural environment. So that is the ontological reality which we cannot ignore. So if you want to be really thoughtful and mindful and progressive about it, that is where we need to move to. But as Sandili said earlier, we need to start somewhere. Now, I just want to make a couple of comments on how do directors deal with climate change. And so I often get the comment, King 4 doesn't deal with climate change because if I put the search word in, climate doesn't come up. Or maybe it comes up once in the introductory parts. But actually, King 4 deals with climate and environmental issues very, very holistically. There's actually a golden thread that you can follow. And so I just want to give you the pointers as to this golden thread because, and the reason I'm doing so is it's almost like a roadmap for directors to use when they want to, when they're wondering how do we contend with climate change as one of the nature risks. So principle 3 talks about corporate citizenship. It talks about the role of the company in society and that you need to be mindful of how society affects you, but you also need to be mindful of how you as a company affect society and that you have certain obligations to society. Society, legislation is an act of parliament. Parliament represents society. So by giving through law, the law is an instrument to give you the legal license to operate as a company. That also means that you obtaining through that same mechanism the social license to operate. And so therefore, that brings to the fore these notions of companies who need to act as responsible corporate citizens because they have social obligations as well. Then I move to principle 4, which is the strategy principle. Principle 4 specifically says that you need to take into account the opportunities and the risks that arise from your connectedness to the context in which you operate. Remember your context, social, environmental, and economical. If you do not have that consciousness of that context in which you operate, how do you develop strategy? And that is what we essentially say under principle 4, the strategy principle. And in fact, I think the only way that we are really going to come to terms and work with risks like climate risk and other nature risks is to flip that risk into an opportunity. That's the only way that at least business companies will be able to contend with it and operate in this environment with success. Then I'll move to, and then I'm not even mentioning everything to you, but also under the strategy principle, we talk about when boards approve strategy, they must take into account the reliance of the company is on all 6 of the capitals, and also how the strategy, when it is executed, will affect each of those capitals. You can see how it threads through. Then I get to reporting. Same story. We say report according to your reliance on the 6 capitals and how your strategy, as it's now been executed, because reporting is hindsight, as it's been executed, how has that affected these 6 capitals? Then I move to remuneration, principle 40. Remuneration talks about how you have to measure performance, not only in financial terms, but also the effects on the other capitals. Then I get to principle 16, which talks about stakeholder inclusivity, saying you can't only look at things from the shareholder or the financial lens any longer. As companies, you need to take into account the interests of all of your stakeholders. And here for me, the constitution to which companies, and especially the Bill of Rights, to which companies are bound specifically, interestingly enough, becomes very topical. So when there's the idea that King 4 doesn't deal with climate change, we deal with it very definitively. We deal with it holistically, and we deal with that. So environmental issues and social issues, like Victoria has said, should be seen as connected as well. And the economy is also connected. That's the triple context. So I just want to conclude by saying that there is, if we think at the way in which our courts have brought these voluntary guiding standards of King 4 into measure whether directors, or to evaluate whether directors are acting in accordance with the expected standard of conduct in terms of their legal duties, there is definitely room for holding directors accountable, even if nothing in our legislative framework changed more than what it has. Even if we don't introduce more climate legislation, I think with how things stand, directors are definitely exposed. The other thing is that I think we should not, and Victoria also made this point, we should not look at climate change in isolation. There are broader issues out there, and companies should have regard to those and how they connect it. And then my last word, and I'm also thinking of the question on double materiality that we had before, is I think it would be a mistake to concentrate only on financial materiality. And the reason I say that is there's hardly, let's think about climate change, because that's what we're talking about. If companies who cause an impact and they think that they could get away with it because it's not a financial risk to them. There's hardly anything these days that doesn't transform into a reputational risk. And a reputational risk becomes a financial risk. So I would be very mindful sitting on a board thinking of that there's this big dividing line between financial risks and impact risks. Impact risks, when they materialize, they often become financial risks. So I wonder if we're not making a separation here where there actually is none. But yes, we start with financial risks. And I'll end where I started. I do think that this is a good starting place, but this is definitely not where we need to end. Thank you.
Right, everybody. Now, unfortunately, we're not going to have much time for more discussions at the moment, but I think, Leanne, as you said, feel free to send emails and we will revert as soon as possible. I think, Leanne, I'll hand over to you for closing remarks.
Thank you very much, Anata. Thank you all for joining us in President Hansi. Really enlightening presentation. I think we need to engage more in the reputational and financial aspects of it. Well, today, we had quite a number of people joining us online. I think at some point, maybe 80 people joining us online. So I'd really like to thank them. And yeah, I hope you all really read the opinion. We didn't get a chance to get into the detail at the time. There's so much in there. I hope boards are listening very carefully to this. I'm certain that civil society is paying a lot of attention. I'm getting emails as we speak about how do we use this opinion to take some key issues forward with civil society actors. So this has signaled change, signaled a moment for us to take this a lot more seriously. And yeah, thanks once again and have a good day, everyone. And goodbye to all of you online.
Thanks for getting this in motion.
Thank you. Thank you. Yes. For those we do have lunch, so please, if you're able to, I know it's been a long couple of hours, please do stay with us.
Now I don't even want to go. Now it's over.